Welcome, curious minds, to the deep dive. Today, we're really setting out on, I think, a crucial mission.
Hmm.
We're going to conduct a thorough exploration of some, well, truly vital pieces of European data protection law.
Yeah.
This isn't just about, ticking boxes or reviewing regulations.
Right.
It's about giving you the clearest, most direct route to becoming incredibly well informed, quickly, comprehensively, on how data protection is actually managed, how it's enforced, and how it keeps evolving across Europe.
Yeah, that's essential.
We're basically going to be your guides through this, let's face it, pretty intricate legal landscape. Our job is to break down these complexities into clear, actionable understanding for you.
That's exactly right. European data protection law and, particularly the GDPR, it's just foundational in a digital world today.
Absolutely.
It's a field that's not just dynamic, it's absolutely critical for anyone handling personal data. It doesn't matter if you're running a business, developing tech, or honestly just living your life online. And the regulatory environment. It's in a constant state of flux, constant evolution, which makes continuous informed learning absolutely key. So our goal today is really to provide that structured understanding.
Precisely. And to make sure we really anchor this understanding in, practical application, we're diving deep into one specific area, Chapter 13 of your source material.
Okay, Chapter 13.
Yeah, this chapter is particularly compelling because it pulls together the operational mechanics of data protection. How do the theories actually translate into active management, into enforcement, into compliance across Europe?
It's where the rubber meets the road, so to speak.
Exactly. So we're going to break it down, topic by topic, in the precise sequence it appears in your sources, just to give you absolute clarity on these different supervision, enforcement, and compliance mechanisms that are currently in play. Right, let's begin to unpack these critical elements. Codes of conduct and monitoring bodies. The self-regulatory landscape from 13.2.4. Okay, our first stop in Chapter 13. It shines a light on something called codes of conduct and also the specialized bodies that are tasked with overseeing them.
Yeah.
I know this might sound a bit
A
formal.
little dry, perhaps.
Maybe, but what's particularly compelling about this area, what makes it really interesting, is how it represents, well, an ingenious way for industries to sort of co-create their own more practical GDPR blueprint for compliance.
It really is a clever mechanism.
Yeah.
You're right. At its core, you've got the European Data Protection Board, the EDPB. They play a absolutely foundational role here.
Okay.
Back in 2019, the EDPB adopted specific guidelines. These were all about how organizations should approach getting their draft codes of conduct approved under Article 40, Paragraph 5 of the GDPR.
Right.
Now, these aren't just, more bureaucratic hoops to jump through. They actually underscore a crucial self-regulatory effect.
Self-regulatory, how so?
Well, imagine a situation, right? The GDPR text is broad. It's principles-based. But you need to apply it to a very specific industry. Let's say healthcare data processing, or maybe a niche technology like, I don't know, voice assistants.
Okay, very specific contexts.
Exactly. The GDPR gives you the big rules. But how do those rules actually manifest in the day-to-day operations of that specific sector? That's where codes of conduct come in.
Uh-huh.
They let organizations, especially groups within a particular industry or sector, define more granular, more tailored rules. Rules that demonstrate their adherence to GDPR principles in a practical, context-specific way.
So like an industry handbook.
Pretty much. Think of them as industry-specific handbooks or playbooks for compliance. They provide clarity where the general law might be a bit ambiguous for a specialized field. They offer a consistent, agreed-upon interpretation for that industry.
That sounds useful.
It is. It doesn't just streamline compliance for businesses, which is obviously important. It also helps build trust with data subjects, with people like you, because they can see a clear commitment to privacy standards within that specific sector.
Okay, so if an industry develops one of these codes, one of these playbooks, what about oversight? I mean, who ensures everyone's actually playing by those specific rules? It can't just be trust, can it?
No, absolutely not. That's a critical point, and the guidelines address it directly. They also cover the accreditation requirements for the monitoring body.
The monitoring...
Yeah, that's the entity responsible for overseeing compliance with these codes. It's all laid out in Article 41 of the GDPR.
Yeah.
And the independence of this monitoring body. It's absolutely non-negotiable.
Why so strict on independence?
Well, think about it. Without genuine independence, the whole self-regulatory aspect just loses its credibility, its effectiveness. It's not just about setting rules on paper. It's about ensuring impartial, robust oversight. Real teeth. This ensures the code isn't just, a document gathering dust somewhere. It needs to be a living document with meaningful enforcement behind it. That fosters genuine accountability. This independence is what makes the self-regulatory model trustworthy for the industry, yes, but also crucially for the regulators and the public.
Okay, that self-regulatory effect sounds pretty ideal on paper, maybe a win-win. But let's be realistic. For a company, especially maybe a smaller one, does pursuing these codes truly simplify their compliance burden? Or does it just add its own layer of, bureaucratic overhead? What's the sort of hidden cost or maybe the unexpected benefit for a company trying to actually put these codes into practice?
That's an excellent, very practical question. And look, drafting and getting a code approved certainly involves an initial investment, time, resources, a form of overhead, just like you said. But the long-term benefit for many companies within a specific sector often outweighs this initial effort. The guidelines themselves, for their part, they don't introduce radical new concepts to how codes of conduct work. Instead, what they do, and this is important, is provide essential insight into the quality of an application that the data protection authorities, the DPAs, will expect to see.
Ah, setting the standard?
Exactly. This is incredibly important practically. DPAs, like any regulator, have finite resources, right?
Right.
These guidelines effectively set a bar. They say, this is what a DPA needs to see before it will invest significant time and effort in a really in-depth review and evaluation of your draft code. It's about efficiency, really, for both sides.
Makes sense.
And they include helpful practical tools, too. There's a checklist, for example, outlining the information that needs to be in an application for approval. And there's a flowchart that illustrates the procedure specifically for transnational codes.
Okay, that sounds helpful.
It is. This structured approach helps industries submit complete, robust applications. It minimizes the back and forth with the DPA and hopefully speeds up the approval process.
You mentioned transnational codes there. That's an interesting term. Can you elaborate a bit? What exactly are those and why do they need a special procedure?
Of course. Transnational codes are, well, pretty much what they sound like. They are codes of conduct designed to affect or apply to data processing activities in at least 2 different member states.
Okay, across borders.
Precisely. Because they have this cross-border impact, their approval process is subject to something called the consistency mechanism that's outlined in Article 63 of the GDPR.
The consistency mechanism, why is that needed?
It's profoundly important. It ensures that data protection rules are applied uniformly across the entire European Union. Think about it. Without it, you could easily end up with a confusing patchwork of different interpretations, different requirements from one member state to the next.
Chaos for businesses, I imagine.
Exactly. It would severely undermine the free flow of data within the Union, which is a key goal of the GDPR, and create huge legal uncertainty for businesses operating across borders. So the EDPB, using this consistency mechanism, ensures a harmonized approach for these codes that apply widely. It is worth noting, though, just as a small aside, the GDPR itself doesn't actually contain specific rules for identifying, say, which entity or which authority should initiate or lead the process for these transnational codes.
Oh, interesting. A gap.
Potentially, yes.
Yeah.
It means there can sometimes be practical questions about coordination among multiple DPAs involved. It's an area that could probably still benefit from a bit more specific guidance down the line, but the overarching goal remains consistency and clarity across the EU for these widely applicable rules.
So for you, as someone navigating this complex landscape, maybe trying to understand where things are heading, understanding these codes means recognizing how industries can proactively, collectively raise their data protection game. It offers a clearer, often more tailored, potentially more practical pathway for compliance that goes beyond just the broad legal text of the GDPR. And ultimately, it should foster a stronger sense of shared responsibility and hopefully trust. 2, independent national regulators, the watchdogs, from 13.4.1. Okay, so we've explored how industries can proactively set their own, more specific standards using these self-regulatory codes. That's one piece of the puzzle. But what happens when that self-regulation isn't enough? Or maybe when an organization simply chooses to disregard the broader rules altogether?
Right, the enforcement question.
Exactly. That's where the critical role of the national watchdogs comes into play, the independent regulators who actually enforce these laws. So let's talk about that. What does this all mean for how the GDPR is enforced on a day-to-day basis across Europe?
This brings us straight into Chapter 6 of the GDPR. That chapter lays out the comprehensive provisions on administrative supervision. And the fundamental starting point, something that really cannot be overstated, is the requirement for every single member state to designate independent public authorities.
Independent, that word again.
Crucial word. Their sole unambiguous purpose is to monitor the implementation and application of the GDPR within their own territory, their own member state. And the GDPR's text is exceptionally clear on this point. These authorities must act with complete independence when they're performing their tasks and exercising their powers.
It's not just a suggestion, then.
Not at all. It isn't merely a suggestion or a preference. This independence mandate is an absolute cornerstone of the GDPR's enforcement framework. It's specifically enshrined in Articles 51 and 52. It's a non-negotiable requirement, and it's designed to ensure impartiality, effectiveness, and critically public trust in their oversight functions.
Why is trust so important there?
Because without that independence, these bodies could potentially be susceptible to political pressures or commercial pressures, and that would entirely undermine their ability to protect individuals' fundamental rights.
Okay, that mandate for complete independence sounds robust on paper. It's written right there in the law. But what does that look like in practical terms for these organizations? I mean, how can we, or how can you, as a data subject, be sure they're truly able to do their job without being maybe bogged down by external pressures or even internal limitations?
That's a really vital question. It touches on the operational reality. A critical feature, indeed the source calls it an essential feature, of any truly independent regulator isn't just their legal mandate written in the law, it's also their practical capacity.
Capacity meaning?
Meaning they must possess sufficient skills and resources to effectively carry out their, frankly, extensive and often very complex tasks. Think about the scope of their responsibilities for a moment. These authorities are on the front lines. They're tasked with investigating intricate data breaches, sometimes involving millions of people. They have to enforce potentially massive fines we'll talk about later. They need to provide nuanced guidance to a huge range of businesses, from tiny startups to giant multinationals and to individuals. And they have to ensure compliance across entire nations.
That's a huge remit.
It is. And it requires highly specialized skills, legal skills, technical expertise. It needs robust IT infrastructure, sufficient staffing levels, and crucially, adequate financial funding.
So independence isn't just legal, it's also about having the means.
Precisely. If a DPA is understaffed, if its technical experts lack the up-to-date knowledge to understand, say, AI or new ad tech, or if it doesn't have the financial backing to conduct really thorough, potentially lengthy investigations, then its independence, no matter how strongly mandated by law, it just becomes theoretical rather than practical.
Right, it's just words on paper.
Exactly. Their ability to investigate thoroughly, to issue timely and impactful enforcement actions, and to provide clear, consistent guidance, it all hinges directly on these operational capabilities. Consider the potential for political pressure you mentioned. An independent DPA needs to be resilient enough, strong enough, to make difficult decisions that might challenge powerful corporations or even government entities.
Yeah, I can see that.
Adequate resources provide a kind of buffer against those pressures. They enable the DPA to stand firm on legal principles. Without these essential resources, they simply cannot fulfill their mandate to protect data subjects' rights effectively, and the whole system of supervision would be severely undermined.
So this independence, both legal and practical, is truly central for you as a data subject. It's meant to ensure that there's an impartial body genuinely looking out for your fundamental rights, free from undue influence from governments, powerful corporations, or shifting political winds. It's designed to be your ultimate safety net in this complex, often quite opaque data protection ecosystem. It should give you confidence that your data rights are championed by an authority with the teeth and the freedom to actually act. 3. International data transfers. Mechanisms for cross-border data movement from 13.4.3.4. Okay, let's pivot now. We're moving to one of the most critical and often, let's be honest, challenging areas in data protection, especially for any multinational organization, and that's the intricate process of moving personal data across international borders.
Yes, Chapter 5 territory, always complex.
Right. This is where the global nature of business, the way data flows everywhere, squarely meets the really stringent requirements of privacy rules. What's particularly complex and I think fascinating here is how these regulations literally dictate the flow of information worldwide. It's a huge deal.
You've absolutely hit on a cornerstone issue. While a core objective of the GDPR, as we mentioned, is to allow the free flow of personal data between member states, basically within the European Economic Area, the EEA.
Treating it like one big digital market.
Exactly, treating the EEA as one unified digital market. But at the same time, It imposes significant and, yes, often challenging restrictions on transfers of personal data to what are called third countries.
And third country just means?
Simple definition.
Right.
Any country outside the European Economic Area.
Yeah.
So the U.S., U.K. post-Brexit, India, Brazil, you name it. If it's not in the EEA, it's a third country for GDPR purposes.
Okay. And the aim of these restrictions?
The aim, as laid out in Chapter 5 of the GDPR, is fundamentally to ensure that personal data, once it leaves the EU's jurisdiction, continues to maintain a comparable level of protection. The term often used is essentially equivalent protection to what it would receive if it just stayed within the EU.
Maintaining the standard, basically.
Precisely. This is crucial for maintaining the integrity of people's fundamental rights, especially privacy, even as their data travels across the globe.
So given these really stringent requirements, what are the main ways, the primary avenues or legal mechanisms that European data protection law actually provides for organizations, whether they're controllers or processors, to legally export personal data from the European Union to one of these third countries? It must be quite a structured process considering how much data moves globally.
Oh, it is indeed highly structured. The GDPR provides several well-defined mechanisms, essentially pathways, for lawful transfers. Let's break down the main ones mentioned in this part of your source.
Okay, let's hear them.
First up, probably the most straightforward, is the whitelist of countries with adequacy decisions.
Adequacy decisions.
Yes, this happens when the European Commission, after a really thorough assessment, formally determines that a specific third country, or maybe its legal framework, its rule of law, sometimes even a specific sector within a country or an international organization, ensures an adequate level of protection for personal data.
So the Commission basically says this place is safe.
In essence, yes. The Commission effectively deems that country or entity safe for data transfers from the UEA perspective. When an adequacy decision is in place for a country, data can flow to that country much like it would within the EEA itself. You don't generally need additional safeguards for that transfer.
Any examples?
Sure. There's a growing list. Countries like Japan, Canada, specifically for commercial organizations covered by their PIPEDA law, New Zealand, Switzerland, the UK post-Brexit, South Korea, Israel, Argentina. Quite a few now.
Yeah.
And importantly, these decisions are regularly reviewed to make sure that adequacy is maintained over time.
Okay, that sounds like the gold standard. If you can get it, what's next?
Second, the source specifically mentions the Privacy Shield arrangement for transfers to the United States. Now, this is where we need to be careful, as the legal landscape moves fast.
Right, I remember hearing about that.
Exactly. While Privacy Shield was indeed a prominent mechanism for transfers to the U.S. when it was active, and it's mentioned here in the source material we're dissecting, it's absolutely vital for you, the listener, to know that the European Court of Justice actually invalidated the Privacy Shield.
Invalidated. When was that?
In its landmark Schrems II decision back in July 2020. This ruling really underscored the dynamic nature of these regulations and just how critical it is to stay current. Mechanisms can evolve, they can be struck down by courts, forcing organizations to adapt really rapidly and constantly reevaluate their data transfer strategies.
What was the issue with Privacy Shield?
The core challenges revolved around concerns about the potential for U.S. government surveillance programs to access data transferred from the EU, and whether that access undermined the essential equivalence of protection required by EU law. Since then, the EU and U.S. have worked towards new frameworks. The latest development is the EU-U.S. Data Privacy Framework, which aims to address the concerns raised by the court. But the point is, this area is constantly evolving.
Okay, noted. Very dynamic. What's the third mechanism?
Third, we have binding corporate rules, or BCRs.
BCRs sounds corporate.
They are.
Yeah.
These are quite sophisticated internal codes of conduct. They apply within multinational groups of companies, think large corporations with subsidiaries all over the world.
Okay.
BCRs are essentially a set of globally applicable, legally binding privacy policies, specifically designed for international transfers of personal data within that specific corporate group.
So data moving between, say, the German HQ and the U.S. branch of the same company.
Precisely. BCRs have to be approved by the relevant data protection authorities. The company has to demonstrate that these internal rules provide appropriate safeguards for the data wherever it goes within the group. They act as a self-imposed but legally binding framework. It's a very robust mechanism, often quite complex and time-consuming to implement and get approved, but it can be highly effective for large, integrated global businesses that transfer a lot of data internally.
Right. Maybe not for everyone, but good for the big players. And the fourth one?
And fourth, and perhaps the most widely used mechanism, especially for transfers outside of corporate groups or where adequacy doesn't apply, are the standard contractual clauses, or SCCs.
SCCs, I've definitely heard of those.
You probably have. These are pre-approved contract clauses. They're issued directly by the European Commission. They contain specific, standardized obligations for both the data exporter, the entity in the EEA sending the data, and the data importer, the entity in the third country receiving it.
So like a template contract.
Essentially, yes, a legally binding template designed to provide appropriate safeguards for data transfers to third countries that don't have an adequacy decision. Now, it's important to note here, too, that the Commission adopted a substantially revamped, modernized version of these SECs back in June 2021.
Ah, new ones.
Yes, new ones. These 2021 SECs introduced a more flexible, modular approach. This makes them more versatile, allowing them to cover different common transfer scenarios, like controller-to-controller transfers, controller-to-processor, processor-to-processor, and even processor-back to controller transfers.
More adaptable, then.
Exactly. And crucially, these new SECs also strengthen the provisions to specifically address the concerns raised by that Schrems court decision we talked about, particularly regarding the assessment of the laws in the destination country and the potential for government access to the transferred data. This makes them a more robust, more reliable mechanism now, although they do come with an explicit requirement to conduct a transfer impact assessment, or TIA.
A TIA, what's that?
It's basically an assessment that companies using the SCCs have to do to check if there's anything in the law or practice of the importing country that would prevent the data importer from actually complying with the SCCs, essentially making sure the contract's protections aren't undermined by local law.
Okay, so SECs are widely used but require some homework. That's a pretty comprehensive set of standard options. Adequacy, the now defunct, Privacy Shield, BCRs, SECs. So are these the only ways to legally transfer data? Or is there any room at all for custom solutions? What if these standard mechanisms just don't quite fit a really unique business scenario? Or if an organization has very specific needs?
That's a good point. While those are the main mechanisms, there is indeed a degree of flexibility built in for more bespoke situations. Article 46, paragraph 3 of the GDPR explicitly enables controllers and processors to obtain authorizations from the respective DPAs for the use of their own contractual models.
Ah, so you can write your own contract sometimes.
You can, potentially. This provides an avenue for highly tailored solutions when the standard clauses or other mechanisms might not be perfectly suited to a very specific or perhaps unusually complex transfer scenario. The key here, of course, is that these custom models must still provide all the necessary safeguards for data protection. They have to undergo rigorous scrutiny and approval by the relevant DPA to ensure they absolutely uphold the GDPR's high standards.
So it's not a loophole.
Definitely not a loophole.
Yeah.
It's a carefully controlled pathway for carefully vetted custom solutions. Additionally, the law also allows public authorities to seek approvals for specific administrative arrangements for transfers, which often involve necessary data sharing between governmental bodies in different jurisdictions, maybe for law enforcement cooperation or tax purposes.
Okay.
This just demonstrates that while the framework is strict and its intent is always to protect data, it also offers these carefully controlled avenues for bespoke legal arrangements where genuinely appropriate. But always with the primary goal of ensuring data protection remains paramount, no matter the mechanism used.
Understanding these mechanisms is absolutely vital, isn't it? Because they are the fundamental legal backbone for how your personal data can flow globally. This impacts everything from your simple online shopping, using cloud services for photos or documents, all the way up to the massive, complex operations of international businesses. It's all about trying to maintain a consistent and high level of protection for your privacy, no matter where in the world your data happens to travel. Further B, wider functions of the EDPB, the central hub of data protection development from 13.5.6.4. Okay, let's unpack this a bit more. We've touched on the EDPB, the European Data Protection Board, a couple of times already, in relation to codes of conduct, the consistency mechanism, but its influence seems to extend far beyond just ensuring uniformity, right? It feels like it's truly at the heart of how data protection law evolves, how it gets interpreted, and how it's applied across the entire European Union.
You're absolutely right to pick up on that. It's a crucial distinction to make, and its broader role is often underestimated. while the EDPB's role in managing that consistency mechanism is significant and vital for ensuring uniform application of GDPR in specific cross-border cases, preventing that regulatory fragmentation we talked about.
Making sure Spain and Germany apply the rule the same way, basically.
Essentially, yes, in relevant cases, but its overall scope of activity is far, far more expansive than just that. If you actually look at Article 70 of the GDPR, you'll find what the source calls a truly long list of tasks assigned to the EDPB.
A long list.
A very long list. And these tasks are broad, they're comprehensive, they effectively enable the EDPB to engage in virtually all areas of data protection. It's not simply, a dispute resolution body or just a coordination committee for DPAs. It's really a proactive developer of data protection understanding and practice across the entire European Union.
How so?
Well, it serves as a central clearinghouse for expertise and interpretation, drawing on the knowledge of all the national DPAs. And that collective wisdom is invaluable for both the regulators themselves and, importantly, for the organizations trying to comply with the law.
Okay, so what kind of activities are we actually talking about here beyond just ensuring consistency? Can you give us some concrete examples of these wider functions, things that really demonstrate its influence and how it actively shapes the practical application of data protection law day to day?
Certainly. One of its absolutely key functions, and probably one of the most visible, is publishing general advice and guidance.
The guidelines we mentioned earlier.
Exactly, but it's broader than just for codes of conduct. This is incredibly impactful.
Yeah.
The EDPB regularly issues detailed guidelines, recommendations, opinions, and best practices on a huge array of topics related to GDPR interpretation and application.
Like what, for instance?
Oh, all sorts. They've issued comprehensive guidelines on really complex issues, like the nuances of using video surveillance in public spaces, or the intricacies of online behavioral advertising and tracking, or the precise requirements for getting valid consent for data processing, especially in tricky contexts like mobile apps or IoT devices.
Really practical stuff, then.
Very practical. These guidelines are pretty much indispensable for organizations and their advisors who are struggling to apply the high-level principles of the GDPR to their specific operational realities. They provide that much-needed practical clarity that data protection professionals and businesses desperately need to navigate the complexities.
Okay, so guidance is one big area. What else?
Another significant task is investigating the effective operation of the regulation in practice. The EDPB doesn't just issue rules from, an ivory tower in Brussels. It actively observes and analyzes how the GDPR is actually being implemented on the ground across all the member states. This involves gathering insights from the national DPAs, identifying common challenges or perhaps areas where non-compliance seems widespread, and assessing the real-world impact of their own guidance and the regulation itself.
So, checking if it's actually working.
Exactly. This practical oversight feeds back into their future work. It informs their future guidance, helps to refine the overall regulatory approach, and helps ensure that the GDPR remains relevant and effective, even as technology changes at lightning speed.
Makes sense. Guidance, investigation. Anything else major?
Yes, there's a third role, perhaps less visible to the public, but equally vital. The EDTB plays a crucial part in assisting the development of the legislative framework itself.
How does it do that?
It does this primarily by providing expert advice and formal opinions to the European Commission. Remember, the Commission is the EU body responsible for actually proposing new EU legislation. So when new laws or amendments related to data protection are being considered, maybe in cutting-edge areas like artificial intelligence regulation, the e-privacy regulation updates, or new data governance models like the Data Act, the EDPB's collective expertise, drawn from all the national DPAs, is sought. They provide input based on their practical experience enforcing the current laws.
So they influence future laws, too.
Absolutely. This advisory role positions them centrally in the continuous evolution of European data protection law. It helps ensure that new regulations are well informed by practical realities, are likely to be workable, and will be effective in safeguarding data rights while, ideally, still supporting innovation.
Wow, that's quite a mandate.
It really is.
Sure.
And it is precisely because of these expansive and influential functions, guidance, investigation, legislative input, consistency, that the source quite rightly states the EDPB will be at the epicenter of developments of the law and practice.
The epicenter.
Definitely. So for anyone serious about understanding or practicing data protection, whether you're a seasoned professional, maybe an academic studying this area, or simply someone who wants to stay informed about your own privacy rights, you are strongly encouraged to keep up to date with the EDPB's work.
How do you do that best?
Well, a particularly valuable resource, and one highlighted specifically in Article 71 of the GDPR, are its annual reports. These reports summarize their activities over the past year, highlight major decisions and opinions, and crucially, often signal key developments and priorities for the coming year. They essentially offer a kind of strategic roadmap for the future of data protection focus in Europe.
So if you really want to stay truly ahead of the curve in data protection, keeping a close eye on the EDPB's publications, their guidelines, their opinions, their annual reports, it's almost like having a direct line to the future of privacy regulations.
It's a good way to put it.
It's a constant source of those aha moments, isn't it? Showing you not just where the law is right now, but where it's undeniably heading and how practical enforcement is actually shaping up on the ground. The maximum fines, the cost of non-compliance from 13.6.2.
Okay, finally, let's wrap up our deep dive into Chapter 13 with, well, arguably the most tangible enforcement mechanism, and frankly, the one that often grabs the most headlines. The maximum fines, the really big numbers that can be levied for noncompliance.
Ah, yes, Article 83, the financial teeth of the GDPR.
Exactly.
Right.
When organizations fall short of these pretty robust data protection standards, the consequences aren't just reputational, although those can be severe too. They are significantly financial. So what does this all mean for organizations operating in this space? What kind of financial impact are we truly talking about here? This is indeed where the GDPR reveals its considerable power, establishing financial penalties designed to be, well, both a deterrent and, importantly, proportionate to the infringement. The financial penalties under the GDPR are structured in two distinct tiers. It's all laid out in Article 83, and the tier depends on the severity and the nature of the specific infringement.
Okay, two tiers. What's the first one?
Under Article 83, Paragraph 4, the data protection authorities, the DPAs, have the power to impose administrative fines of up to 10 million euros. Or, alternatively, 2% of the organization's total worldwide annual turnover in the preceding financial year, whichever amount is higher.
10 million or 2% worldwide turnover, whichever is higher. Okay,
Right.
what kind of violations trigger that level?
This tier, the lower tier, typically applies to infringements of specific obligations that, while serious, might be considered less central to the absolute core data protection principles. We're talking about obligations relating to things like getting verifiable parental consent for children's data, implementing data protection by design and by default principles, maintaining proper records of processing activities, their Article 30 records, cooperating fully with regulators when they investigate, implementing appropriate technical and organizational security measures, notifying breaches to the DPA and sometimes individuals in a timely manner, conducting data protection impact assessments, DPAs, where required, appointing and supporting a data protection officer, DPO, if needed, and adhering to approved codes of conduct or certification mechanisms we discussed earlier.
So, more about the operational and procedural side of things being correctly implemented.
Broadly speaking, yes. It's about ensuring the operational plumbing and the procedural safeguards are correctly in place and followed. Still very important, and the fines are still substantial, but it's distinct from violations of the core principles themselves.
Right. So what about the higher tier then?
Okay, then under Article 83, Paragraph 5, for what are considered the more severe infringements, those thresholds are significantly raised. For breaches of the most fundamental principles and rights under the GDPR, fines can go up to a truly staggering 20 million euros, or 4% of the total worldwide annual turnover in the preceding financial year. Again, crucially, whichever amount is higher.
20 million euros or 4% worldwide turnover. Wow, what falls into that category?
This higher tier applies to infringements of the core data protection principles themselves, the absolute bedrock of the regulation. So we're talking about breaches related to the fundamental principles for processing found in Article 5, like lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. It also covers violations concerning the legal basis for processing, especially the strict conditions for obtaining valid consent. Processing sensitive special category data, like health or biometric data, without a proper legal basis falls here too. Critically, infringements of individuals' fundamental data subject rights, like the right to access their data, the right to rectification, the right to erasure, right to be forgotten, the right to restrict processing, the right to data portability, or the right to object those, all trigger the higher tier.
So, violating people's actual rights.
Exactly. Also, violations of the rules governing international data transfers, which we just discussed, transferring data outside the EEA without adequate safeguards. And perhaps critically, A failure to comply with an order or instruction from the DPAs themselves, like ignoring their investigatory powers or corrective measures they impose. These are the infractions that are seen as directly undermining the very essence of data protection.
That's a truly vast range between the two tiers, and those numbers, especially the 4% of worldwide turnover, really underscore the seriousness. How do the DPAs actually decide, first, which of those tiers applies in a specific case? And second, what other factors come into play when a DPA determines the actual amount of the penalty within those broad limits? I mean, it can't just be arbitrary, pick a number between 0 and 20 million.
No, you're absolutely right. It's far from arbitrary. There's a structured process. Before even applying those percentages of the fixed caps, 10 euro or 20 meters, the DPAs first need to establish whether the entity they're finding is categorized as an undertaking or a non-undertaking.
Undertaking versus non-undertaking, what's the difference?
Well, our source material here doesn't go into the detailed legal definitions, but generally speaking, an undertaking refers to any entity engaged in economic activity, regardless of its legal status or how it's financed. This typically covers most businesses, large or small, for-profit companies. And it's usually for undertakings that the turnover-based fines, the 2 or 4%, become relevant, because they have a turnover figure to calculate against.
Okay, so businesses mostly.
Mostly. A non-undertaking, on the other hand, might refer to, say, a public authority, maybe a government department, a university acting in a non-commercial capacity, or perhaps a nonprofit organization that doesn't engage in economic activity as its primary function. For these types of entities, the fixed monetary caps, the 10 million or 20 million limits, would typically apply as the ceiling, rather than a percentage of revenue they likely don't generate in the same way. So this initial classification, undertaking or not, sets the fundamental maximum potential penalty.
Right, establishes the ceiling. Then what?
Then beyond that crucial categorization, the GDPR itself, in Article 83(2), mandates that a whole list of various aggravating or mitigating factors must be considered when calculating the final specific fine amount. The goal is to ensure the fine is effective, proportionate, and dissuasive in each individual case.
Aggravating and mitigating factors. Like what?
The source provides one key illustrative example from the list in Article 83(2), noting that Factor K considers any financial benefits gained or losses avoided directly or indirectly from the infringement.
Ah, so if the company actually profited from breaking the rules.
Precisely. If a company profited from its non-compliance, or perhaps saved money by not implementing required security measures, that ill-gotten gain or cost saving will likely be factored into the penalty, potentially increasing it significantly. The idea is that non-compliance should never pay.
Makes sense. What other kinds of factors are typically looked at? The source implies there's a longer list.
Yes, Factor K is just one example. Though not detailed in the specific section of our source, the full list in Article 83(2) is quite comprehensive. Other factors that DPAs must consider include things like the nature, gravity, and duration of the infringement, for instance. How many people were affected? How long did the breach or violation last? What categories of personal data were involved? Was it highly sensitive health data or just basic contact information? The intent or negligence involved, was it an intentional violation or just a mistake? The degree of responsibility of the controller or processor, taking into account the technical and organizational measures they had implemented or failed to implement. Any relevant previous infringements by the same organization. Critically, the degree of cooperation with the supervisory authority to remedy the infringement and mitigate its possible adverse effects. The categories of personal data affected. Whether the organization notified the authority of the infringement proactively. Adherence to approved codes of conduct or certification mechanisms, which can be mitigating. Effectively, it's a holistic assessment looking at the company's behavior, the context, the impact of the infringement, and their response.
So it's a very detailed case-by-case assessment.
Extremely case-by-case. And for data protection professionals and organizations who really want to get into the weeds of how these administrative fines are calculated in practice, the EDPB, which we just discussed, has issued comprehensive guidelines 042022 on the calculation of administrative fines under the GDPR. They were published back on May 12, 2022. These guidelines provide a much more detailed, standardized methodology that DPAs across the EU are expected to follow when setting fines. This aims to bring more consistency, predictability, and transparency to the finding process across the different member states.
Okay, that sounds like a key document for anyone in this field. So these huge figures, these potential fines, they aren't just abstract numbers designed to scare people, are they? They represent a truly significant, concrete incentive for organizations to embed data protection deeply and genuinely into their corporate DNA, to move beyond just, superficial tick box compliance.
Yeah.
And for you, as someone invested in understanding this landscape, whether professionally or personally, it's a really clear signal of the serious commitment required to safeguard personal data. It reinforces that privacy isn't just some vague ethical ideal anymore. It's a fundamental legal obligation with very real, very substantial financial repercussions if ignored. And there you have it, a pretty thorough deep dive into the key elements of Chapter 13 of European Data Protection, as presented in your sources. We've journeyed through quite a lot, actually. The intricacies of those self-regulatory codes of conduct, understanding how industries can potentially shape their own compliance standards. We explored the vital role and, critically, the essential independence of the national data protection regulators, the crucial watchdogs ensuring the rules are followed.
Yep, the DPAs.
We then navigated the complex but absolutely crucial mechanisms, adequacy, BCRs, SCCs, and the like, that enable international data transfers while trying to maintain robust protection levels.
A constantly shifting area.
Indeed. Our discussion also covered the surprisingly expansive and evolving functions of the EDPB, positioning it as the central hub of privacy law development and interpretation in Europe.
Right at the epicenter.
And finally, we detailed the very substantial financial implications, those maximum fines, for organizations that fail to comply, demonstrating the significant teeth the GDPR really possesses.
Indeed. And I think what becomes really clear from this kind of deep dive is that effective data protection isn't merely about avoiding fines, although, let's be realistic, that's certainly a powerful motivator for many organizations.
Can't ignore those numbers.
You really can't. But fundamentally, it's about building and maintaining trust with individuals, with customers, with employees. It's about fostering a genuine culture of accountability within organizations. And ultimately, it's about operating ethically in an increasingly data-driven world. Remember, as the source material emphasizes elsewhere, knowledge is most valuable when it's understood and applied. And critical thinking is absolutely essential in navigating the vast, sometimes overwhelming landscape of information around data protection. The ultimate goal here has to be moving beyond just superficial tick box compliance to a deeply embedded, proactive culture of data protection within organizations.
Absolutely well said. And as you, our listener, reflect on how all these different elements, the codes, the regulators, the transfer rules, the EDPB, the fines, how they all intertwine, creating this complex but vital ecosystem for privacy. Maybe consider this final thought. In our increasingly digital, increasingly borderless world, how might the relentless, rapid evolution of technologies like artificial intelligence, perhaps quantum computing down the line, maybe even neurotechnologies, how might these further challenge and perhaps even fundamentally redefine the very concepts of personal data and privacy as we understand them today?
That's a huge question for the future.
It is, and it will undoubtedly require continuous adaptation, continuous evolution from both the regulators like the EDPB and the national DPAs, and from all the organizations handling data. It's pushing the boundaries of everything we've just discussed and constantly opening up new frontiers, new challenges for data protection. That's all the time we have for this particular deep dive. Thank you so much for joining us on this exploration of Chapter 13 of European Data Protection. As always, keep asking questions, keep digging deeper, and stay curious.